Okay, good afternoon, and if you're joining us from the Pacific time zone, good morning still, and welcome to the Holland & Hart Health Law webinar series. My name is Derek Curl. I am a partner at Holland & Hart. Today, we'll be covering the Telephone Consumer Protection Act and how to comply with that act in the healthcare industry, and understanding and mitigating the risks that come under this federal statute. By way of introduction, I have been at Holland & Hart for about 10 years, and before that I was with a national firm for a few years. I specialize in representing businesses in complex litigation, including litigation involving today's topic, the TCPA. I also advise clients on TCPA compliance and how they can establish policies and procedures to comport with the requirements of the TCPA. My contact information is on this slide, and including my LinkedIn, so feel free to reach out and connect either by LinkedIn or by email. This presentation today is being recorded, and the recording and materials from this presentation will be available at www.hhhealthblog.com and clicking on the webinar recordings tab there. If you have any questions during the presentation, you can submit them in the chat box or you can shoot me an email. Just to give you an overview and a roadmap of where we're headed today, I'd like to give you an overview of the TCPA. We'll talk about a few litigation trends that we've seen over the last few years in this space, discuss some recent important regulatory and legal developments. We'll be talking about some healthcare exemptions to the statute, and then I'll be going over a few best practices. So that's where we're headed today as we go forward. So let's dive in. The Telephone Consumer Protection Act was established and enacted in 1991 by the U.S. Congress to combat aggressive telemarketing and fax advertising practices which were believed to invade consumer privacy. Now, the technology is different now and has come a long way since 1991. And so the TCPA is now being interpreted to apply to this updated technology. So the TCPA applies to text messages and to calls to mobile phones. Under the TCPA, the U.S. Congress empowered the Federal Communications Commission, or the FCC, to interpret the TCPA through rules, regulations, and other declaratory rulings. And one of those declaratory rulings is a pretty important one, and it's one we're going to talk about in a few minutes. So let's dive in a little bit further. The TCPA and its implementing regulations make it unlawful for a company or a provider to use what's called an automatic telephone dialing system, or an ATDS or an auto dialer, or to use artificial or pre-recorded voice to deliver calls or text messages to cell phones without the prior express consent of the recipient. And so the nature of the prior express consent differs depending upon the nature of the call. For telemarketing and advertising calls, those calls require prior express written consent. And for non-telemarketing and informational calls require prior express consent. And we'll talk a little bit more about what that consent looks like in a few minutes. The TCPA and its implementing regulations also prohibit telemarketing and advertising calls using artificial or pre-recorded voice to residential lines without prior express consent. The statute also forbids the use of fax machines to send unsolicited fax advertisements. Again, this is part of the statute where the technology is really not in much use anymore. There are a few usages of fax machines, but this is a part of the statute that really doesn't get a lot of play nowadays. And then the statute also regulates telemarketing, including the do not call registry, time of day calling restrictions, and company-specific do not call lists. I'd like to take a few minutes and talk about enforcement of the TCPA. It is enforced through the FCC, at times through the FTC, through states' attorneys general, and through private plaintiffs. But the single biggest risk for businesses is through private litigation. The TCPA creates a private right of action where private plaintiffs, consumers, may obtain statutory damages of $500 per call, or actual damages, whichever is greater, and up to $1,500 per call if the call is found to be willful or knowing in violating the TCPA. For example, if a company sends 10,000 text messages at $500 per text, that means the company faces potential liability in damages of $5 million and up to $15 million if the conduct is found to be willful. There is no cap on the amount of statutory damages that can be awarded, and courts, in addition to awarding damages, can award injunctive relief, which means that they can order the company or the calling company to stop, to cease and desist its activities in that way. And so this is a statute that has some teeth. It is and makes for fertile ground for class action complaints. I'd like to talk a little bit about some of these complaints that we've seen over the years and some of the settlements which have come out of those complaints. So you look at this graphic here. This just gives you a snapshot of some of the recent class action settlements involving some big names. Just to touch on a couple of these, Sirius XM Radio, for example, that was a $35 million settlement. Those were calls using an ATDS or an auto dialer to XM Radio trial users to induce them to subscribe. In Bank of America, a $32 million settlement. Bank of America used calls and texts using an auto dialer related to credit card accounts and residential mortgage loans. These calls were actually made to existing account holders, but they were made with no prior consent, and therefore there was a class action brought and ultimately a settlement in the amount of $8.5 million. Capital One, the largest TCPA settlement that we know about in history, $75.5 million. These were calls made to collect on credit card debts using an automatic dialer, an ATDS, without prior express consent. Now, the healthcare sector has not been immune from these types of lawsuits. This next slide, these are settlements which have occurred in the healthcare industry. You'll see a few names up there. One, Kaiser Permanente was that one, $5.4 million settlement. That involved pre-recorded messages to Kaiser's former customers who had canceled their health insurance coverage, and they subsequently received calls that encouraged them to then reapply for coverage. There was a lawsuit brought there and a settlement reached. If you look at Anthem, they were found to have violated the TCPA when when its agents made unsolicited telemarketing calls related to its services to cell phones using an automatic dialer. Walgreens, an $11 million settlement. This involved pre-recorded prescription reminder calls. And Cynosure is a smaller operator, but you can see the fine was not small, or the settlement was not small. This was an aesthetic laser procedures company who had to settle a case involving fax advertisements for seminars for its hair removal and skin treatment products. And then Pharmaerica, this is also an interesting one, a pharmacy that serves long-term healthcare facilities. There was a claim against them for unsolicited fax ads sent to a class of nursing homes. So you can see that, again, that the healthcare industry is not immune from these types of lawsuits and from this type of liability. I'd like to talk a little, well, actually, before I do, I'd like to show you one last note on enforcement. This next slide shows some filing trends over the last 9 years. We don't have the 2019 data, obviously, but as you look at this, there has been an exponential rise in the amount of TCPA claims over the last 9 years. And it's sort of peaking out, it appears, in 2016 with nearly 5,000 lawsuits filed. It's tailed off a little bit from that, but nevertheless, in the last year, still 3,800 lawsuits filed asserting violations of the TCPA. So this has been an active area of litigation over the last 9 years, and again, an exponential rise in the amount of TCPA-related complaints filed. So I want to talk about a couple of aspects now of the TCPA that you need to be aware of going forward. These are some very important aspects, and you'll see why as we go forward. But first, addressing the question, what is an automatic telephone dialing system? What is an ATDS? Well, this is something that is been broadly defined. It is defined by the statute as equipment which has the capacity to store or produce telephone numbers to be called using a random or sequential number generator, and then the capacity to dial such numbers. Well, this begs the question, what does capacity mean? Does this mean present capacity? Does it mean future capacity? Does it mean the capacity to make these calls with some adjustments to the auto dial device? Does it mean capacity when there was human intervention involved in some part of making the call? These are the questions, hotly contested questions that have been argued about, and as you'll see in a few moments, very recently, companies have grappled with, and courts have grappled with, what does an ATDS mean? What does it entail? And we'll talk a little bit about some of those developments as we move further in the presentation. Now, another aspect to talk about here is prior express consent. In the land of TCPA, consent is king. Obtaining that consent is very important. If you have prior consent and can demonstrate it, it is a complete defense to liability, and it is the strongest defense to liability under the TCPA. The level of consent that is required, again, depends upon the content of the message. So, for example, informational calls require a lesser form of consent. They require prior express consent, but you note they don't require prior express written consent. The FCC considers informational calls are those which are expected or desired by consumers. It includes calls on behalf of these listed entities here, nonprofits, political messages, airline notification, fraud alerts, payment reminders, school notifications. Those types of calls are considered to be those that are at least welcomed or at least desired by customers. You know, the other thing that's interesting to note is courts have found, and the FCC has found, that providing a number, either a mobile number, orally or in writing, has been considered to be consent sufficient for, or prior consent sufficient for informational and transactional messages. But you've got to be careful. The call must be closely related to the purpose for which the consent was given. So you need to be careful about obtaining a telephone number for an informational purpose and then calling that number for some unrelated purpose, including and especially if that purpose is an advertising purpose. So let's move forward on consent. For telemarketing and advertising calls, those calls require prior express written consent. That prior express written consent is defined as an agreement in writing bearing the signature of the person called and which clearly authorizes the caller to deliver advertisements or telemarketing messages using an automatic telephone dialing system or delivering that message using artificial or pre-recorded voice. And that agreement must provide the telephone number to which the signatory authorizes such advertising messages or telemarketing messages to be delivered. And a little bit more about that, the FCC has said that written agreements must be clearly and conspicuously put forth and must disclose clearly and conspicuously that the agreement authorizes a caller to deliver telemarketing calls using an auto dialer or artificial or pre-recorded voice, and that the person is not required to agree as a condition of receiving goods and services. So you cannot, at least as the TCPA is concerned, seek that consent, and if it is not given, withhold goods or services as a condition of that consent. The agreement also must provide the consumer's wireless number and his or her signature. So again, it's very important that whatever consent you are seeking must be clear about what it is you plan to do. Informed consent is very important. Moving forward, I want to discuss what has been a key development in this area over the last few years, and it started with a declaratory ruling which was issued by the FCC in July of 2015. The purpose of this declaratory ruling was actually to provide some guidance to companies seeking to comply. I think the effect was something different from the clarity that I think was intended. The order dramatically expanded the definition of capacity that we talked about a few minutes ago in the ATDS definition. The FCC ruled that a system that is not presently being used as an ATDS but nonetheless constitutes an ATDS, well, sorry, let me step back there. It ruled that the system that may not be presently being used as an ATDS will nevertheless be considered an ATDS for TCPA purposes if the system has a potential ability to store and produce telephone numbers using a random or sequential number generator, and then the ability to call such numbers. To put it differently, the characterization of a system is not limited to its current configuration, but also takes into account any potential functionalities or future possibilities. This, as you might imagine, is a dramatic was a dramatic broadening of the definition of what is an auto dialer under the TCPA. The Commission still noted that whether a system is an ATDS is still a case-by-case determination, but this definition that they determined was really extraordinarily broad, and as you'll see in a moment, created some problems. The declaratory ruling also went into some discussion of who is a called party. Certain calls are prohibited unless they are made with prior consent of the called party. The declaratory ruling grapples with who is the called party. Is that the subscriber of the telephone? Is it the phone's common user? Who is it? Who is considered to be the called party? The declaratory ruling also determined or attempted to clarify what is known as the reassigned number problem. Let's say, for example, you have consent from a caller to make a call to that number, but then that number is later reassigned. It's a common occurrence these days. At that point, you no longer have consent to call that person, and at that point, open yourself up to liability. Are you safe in this instance? And the question was asked, are you safe in contacting the intended recipient? With respect to who the called party is in this regard, the declaratory order concluded that the term called party should be defined as the subscriber. The consumer assigned the phone number dialed or billed for the call, or the non-subscriber customary user. The commission, the FCC, rejected requests to construe a called party as an intended recipient of the call, and stated they provided this reassigned numbers safe harbor that basically said that when calls are made to reassign numbers, and it's made to someone intended to be made to the previous subscriber, not the current subscriber, the current user, then there's some liability there. The order provided a safe harbor, one call, that's all safe harbor, I'll call it, which means that you could make one call to the called party without incurring any liability, but the next call that you make, you would be liable, regardless of whether in that first call you discovered whether the called party was the subscriber who had provided prior written consent in the first place or not. And you can see the problem that creates as well. So what happened as a result of the declaratory ruling? Well, it was challenged in the courts. 9 companies filed petitions for review with the U.S. Court of Appeals for the District of Columbia. The petitions were later consolidated into a single case known as ACA International versus Federal Communications Commission. The petitioners challenged a few aspects of the declaratory order. One, the most obvious one, they challenged and asked what type of dialing equipment constitutes an auto dialer or an ATDS under the TCPA. They challenged whether placing a call to a number which has been reassigned violates the TCPA, so they challenged this one call that's all reassignment rule, safe harbor rather. And they also challenged 2 other aspects, which we'll talk about in a minute, how a party may revoke prior consent to receive calls from an auto-dialed call, and also address the scope of the SEC's exemption from the TCPA's consent requirements for certain health-related calls. And we'll go into that one in a little more detail, as I know it applies directly to many of you on the call. So what happens? Well, they filed this, they argued it before the court, and then waited what seemed like a very long time for many of these companies. But finally, in March of 2018, the D.C. Circuit issued its long-anticipated opinion on these issues. It was a split decision. To sum up, the court set aside the FCC's effort to clarify the types of calling equipment that fall within the TCPA's restrictions. They vacated the agency's approach to calls made to a phone number previously assigned to a person who had given consent, but their number had since been reassigned to another person who had not consented to receive such calls. So those were 2 aspects which they struck down in the order. The D.C. Circuit ended up upholding and affirming the FCC's approach to revocations of consent, and we'll talk about that in a moment. And they also affirmed the FCC's exemption for certain time-sensitive healthcare calls. With respect to the ATDS, let's drill down a little bit here. The court, again, struck down the 2015 sweeping definition of an ATDS as unreasonably and as impermissibly expansive. The court found the FCC's definition of the capacity to include future possibilities to be eye-popping, their words, not mine. They also stated that the FCC's interpretation of capacity effectively rendered every smartphone an ATDS, and that essentially makes every American a TCPA violator in waiting, if not a violator in fact. And so that created a real problem. The order also was criticized for failing to offer meaningful guidance on whether equipment was subject to an ATDS restriction. And it also basically, at the end of the day, said equipment cannot be defined as an ATDS based on its future potential capacity to dial numbers. So in short, the DC Circuit gutted every part of this aspect of the 2015 order. It also set aside the order's treatment of reassigned numbers. The court determined that the one-call safe harbor was arbitrary and capricious. It was inconsistent. They basically determined that the order, the 2015 order, was internally inconsistent because the reasonable reliance standard that the commission used to justify a one-call safe harbor was inconsistent with their evaluation of consent elsewhere in the order. And the FCC was criticized for its one-call safe harbor. It basically says, well, if the caller's reasonable reliance on a previous subscriber's consent is reasonable in one instance for one call, why wouldn't it be reasonable for calls thereafter? And so the FCC failed to explain why a caller's reasonable reliance on a previous subscriber's consent ceases to be reasonable once there has been a single post-assignment call. And basically the one silver lining for the FCC is the DC Circuit did rule that it was permissible for the FCC to interpret called party to include current subscriber instead of the intended recipient of the call. The court, in making this ruling, also acknowledged the practical effect concerning the reassignment of millions of numbers on an annual basis. And what I mean the practical effect is the difficulty in companies wishing to comply with the TCPA but faced with the reassignment of these numbers and dealing with those issues. And so that was a nod to understanding or a nod to the complaining petitioning parties and to the practical realities of administering reassigned numbers. Going to the sections which the court upheld, they upheld the 2015 order's determination on revocation of consent. A called party may revoke consent previously provided at any time and through any reasonable means that clearly expresses a desire not to receive future messages. So this consent can be orally or in writing, and the court was careful to say that callers may not unilaterally abridge a called party's right to revoke consent. So in the first instance, you can't, when you're obtaining that consent, you can't say, well, you can't revoke consent at any time. That's just not permissible under the TCPA. Any revocations which are provided must be timely honored, including immediate removal of the number from the company's database. But the court also realized that companies should take a reasonable approach here and should not engage in unduly burdensome procedures to ensure that all revocations provided don't fall through the cracks. So it was basically a reasonableness standard that was put into place by the court. The ACA decision also left open the door for companies and consumers to contractually agree on procedures for revoking consent to call. And that's an interesting practical aspect because, and one that's actually being litigated a little bit right now. There have been some courts where someone tried to revoke in a way, they tried to revoke consent and in a way that was different from what was expressed in a contractual agreement between the called party and the caller, and the court upheld and said that the caller had to use the means of revoking which were agreed upon by the caller and the called party. So this is an interesting issue. It's one that it remains to be seen how this will completely play out as things go forward. And then finally, the other aspect, and one which I wanted to spend a few minutes on, is the exigent healthcare treatment exemption. The court affirmed the FCC's decision to exempt certain health-related calls from the TCPA's prior express consent requirement. Under the 2015 order, calls which had an exigent purpose or for which an exigency exists that also have a healthcare treatment purposes are exempt from the prior consent requirements of the TCPA. And the 2015 order actually provides some examples of what these calls and messages are. And I've listed them here: appointment and exam reminders, confirmations, wellness checkups, hospital pre-registration instructions, the preoperative instructions, lab results, any post-discharge follow-up, prescription notifications, and some home health care instructions. All of these are considered to be exempt from the prior consent requirements, provided that they fall within the other conditions of this exemption. The court and the FCC are careful to point out that this exemption does not cover calls related to accounting, billing, debt collection, or other financial content, even though those calls might be related to the treatment which was received by the provider. And so they went out of their way to say those calls do not qualify for this exigent healthcare treatment exemption. And of course, calls that include telemarketing or advertising content also do not fall within the purview of this exemption. Now, I want to make sure also you understand that there's more to this exemption. There are some additional conditions which you have to meet to qualify, and these are important to note. The call or text message must be sent only to the mobile number provided by the patient. The patient cannot be charged or have the call or text counted against limits of the mobile plan. The name and contact information of the healthcare provider must be stated at the beginning of the call or included in the text message. That's an important aspect of any calls or text messages which are made pursuant to this exemption. And the message or call must be concise. It's got to be less than a minute or 160 characters or less. And there are limits as to the time of day and the frequency of these calls: one call or text message per day, no more than 3 calls in a week. This last aspect, the opt-out aspect, is also an important one. Each message to be eligible for the exemption must offer recipients an easy way to opt out of receiving future messages. And this can take the form of a voice-activated or key press-activated mechanism or some toll-free number for those messages which are calls. And for text messages, replying stop or quit, providing that option in the opt-out mechanisms. And the FCC has been very clear that all opt-out requests must be honored immediately, again, to comply with this exemption. And of course, in order to comply with this exemption, you must also comply with any applicable HIPAA privacy rules. So let's, we want to take a few minutes and talk about what the landscape looks like since ACA International came out. The FCC basically had to go back to the drawing board in a few ways. Basically, what it did was in May and June of 2018, it sought comment on what constitutes an ATDS, how a called party may revoke prior express consent to receive calls and texts, and how to treat calls to reassign numbers under the TCPA. With respect to this latter issue, in December of last year, the FCC issued a new rule establishing a single reassigned number database, which supplements commercial solutions. And this rule essentially provides a safe harbor from liability for under the TCPA for callers who use the database and then reasonably rely on the information that this database provides. So, for example, to qualify for the safe harbor, a caller must show that it had prior express consent of the called party, and then it issued a query on the database of the most recent number information that the called party had, and to verify whether the number was reassigned or not. And then the safe harbor shields the caller from liability should the database return an inaccurate result. While I mentioned here that it was established, that means that the rule was put in place to establish a reassigned numbers database. But in that rule, it said that this will be administered by a private company, and that means to me that it's not yet fully effective. So stay tuned on that. Okay. I'm going to shift gears. Actually, I'm going to look here. I think we have a couple of questions. I could find them. Yes, we're going to talk about, one of the questions is, can you talk about healthcare information text, and actually we're going to address, we've addressed that issue, and we're going to address that a little bit further. And actually, I'm going to hold some of these questions because I think some of them will be answered here in a few minutes. So let me go forward here, but I will get your questions. Thank you for asking them, and if as they come up, please pose them, and we will address them. Just one other comment on the post-ACA international landscape. Courts since ACA came out are still dealing with some of the fallout of the ACA's decision on the FCC's rulings with respect to the ATDS and how it applies. The tricky part here is that there were many rulings regarding the ATDS or automatic dialers, and the court's decision could be read to have thrown out all of those. And some courts say, yeah, they throw out all previous FCC rulings on ATDS, they're out. Some courts have said, well, it doesn't overrule all of those prior rulings, just the 2015 ruling. Other courts said, well, it overturned some of those prior rulings, but not those which deal with human intervention rule. And that rule is basically that if there's some level of human intervention involved in making the call, then that call may or may not be considered to be by an ATDS. It's not an auto dialer if there's some level of human intervention. And other courts have essentially reverted back to the statutory definition of an ATDS going forward. So the courts are still grappling with some of this fallout of the DC Circuit's order, and it remains in many ways a open question on some of these issues, and it remains unsettled. So moving forward, I want to talk about a few more healthcare exemptions to be aware of. One is healthcare messages to residential landlines, so calls to residential lines that deliver a healthcare message from a HIPAA-covered entity or its business associate are completely exempt from the TCPA, and so obviously they'll be exempt from they don't need to seek consent of the called party for these particular calls. And we'll go into what a healthcare message means in just a moment. The other exemption is become known as the healthcare rule. Calls and text messages to mobile phones using an auto dialer or an artificial or pre-recorded message that deliver a healthcare message from a HIPAA-covered entity or its business associates are exempt from the prior express written consent requirement, but only are required to obtain prior express consent. Such consent, as I mentioned previously, is often shown by a call recipient providing his or her mobile number at the time of treatment. I think I'd like to provide some more context to what a healthcare message is. I think it's important to understand. For a call or text message to be considered a healthcare message, it must deliver a healthcare message that, as that term is defined under HIPAA. HIPAA, as you all well know, defines healthcare as care, services, supplies related to the health of the individual. And it includes some of these items that I've listed on this slide: preventative, therapeutic, rehabilitative, counseling services, anything that goes to the health of an individual is considered related to healthcare, and also the sale and dispensing of drugs, devices, equipment, etc. So those messages which go to those aspects are considered to be a healthcare message. Again, I think it's worth being careful about not mixing your messages, as it were, and not including in your message, in a healthcare message, advertising content or telemarketing content, because that content can be deemed to violate the TCPA. Here's another definition of healthcare message provided by one of the courts. It's a little shorter than the one that I just gave, but it addresses, a healthcare message is one which addresses the individual health care needs of the recipient. It addresses a health-related product or service, and it is made by or on behalf of a healthcare provider with an established treatment relationship. I want to provide just a couple of examples to give a little color to these exemptions. One key one is the Latner versus Mount Sinai Health System, which was issued in 2018, and this decision was an interesting one. Latner had visited a Mount Sinai facility known as West Park Medical Group for an examination in 2003. At that time, he made that visit. He filled out new patient forms, including signing a form containing his contact information and a patient notification granting Mount Sinai consent to use his health information for payment, treatment, and hospital operation purposes. In 2011, several years later, Mount Sinai hired a third party to send text messages on its behalf, including transmitting flu shot reminder texts for West Park. Latner returned at that time for some treatment. He declined any immunizations. And then in 2014, he received the following message, which I have up on the screen there, and you can read it. It's flu season again. Your PCP at WPMG is thinking of you. Please call us to schedule an appointment for a flu shot. Latner didn't like this, and he sued Mount Sinai and WPMG under the TCPA. Well, what was the result here? Well, I'll show you. It was raised in the U.S. District Court for the District of New York, and that court held that the text message was a healthcare message, and therefore it qualified for exemption under the healthcare rule and was exempted from the prior express consent requirements under the TCPA. So this was a victory for Mount Sinai. At the district court level, Mr. Latner appealed the decision to the Second Circuit, and The Second Circuit agreed with the district court and provided some other key factors in its decision. One was that Latner had provided his mobile number when he first visited in 2003. Two, that the privacy notices stated that West Park could use his information to recommend possible treatment alternatives and other health-related benefits and services, and that the flu shot reminder was considered to be a healthcare message made by or on behalf of a HIPAA-covered entity, and that Latner had provided prior express consent to receive such messages. So you can see there's an application of the healthcare rule to immunize, if you'll excuse the pun, this hospital organization from liability under the TCPA. Let me give you just a touch on a few more examples. I don't want to take too much more of your time today, but the Zani case in New York. Zani, this was one of those prescription cases. Zani had filled a prescription with Rite Aid in 2013, and on that day, in September of 2013, he provided his cell phone number along with some other personal information. Zani had filled prescriptions at this Rite Aid at least twice more after that, and each time the prescription was filled at this location, he signed a notice of privacy practices, which indicated that Rite Aid may contact Zani to provide refill reminders, information, and other information about treatment alternatives or other healthcare benefits. Zani later obtained a flu shot at the same pharmacy later that year, and then he received another phone call a year later with a pre-recorded message, again talking about the availability of flu shots for the upcoming flu season. Zani again sued Rite Aid, and the court ultimately found that this message, this pre-recorded voice message conveying a flu shot reminder, was a healthcare message, and that prior express consent had been provided when Mr. Zani provided his number, and so therefore there was no TCPA liability. Now, so these are a couple of good cases. For sake of time, I'm not going to go into the Bailey case, but it's a similar prescription reminder case. It's important to point out that not all courts have agreed, and the facts and circumstances are different. In Coleman versus Rite Aid of Georgia, Coleman received a pre-recorded automated voice message from Rite Aid regarding prescription medications, and this was received on his mobile phone. Unfortunately, the calls were directed to someone else. They were not directed to Coleman, but he was receiving them nonetheless. Coleman requested that Rite Aid stop sending messages, but he continued to receive them. And because when the court was looking at this, the court determined that Mr. Coleman did not provide any consent, and therefore the health care rule did not apply. The defendant, Rite Aid, tried to invoke the exigent healthcare treatment exemption, but that also did not work. And the reason for that was one of the reasons was that no opt-out mechanism was provided to Mr. Coleman, and when he tried to opt out, meaning when he requested that they stop, it was not honored. And so Coleman's a cautionary tale, but it also is an example of what not to do in this set of circumstances. The Rite Aid had some chances to stop making the calls, and one of them was to comply with his request, and it just didn't happen here. So a couple of other things. I wanted to just, before I take some questions and we wrap up here, I wanted to give you some best practices to remember, some do's. One important thing to do is to develop and to implement a TCPA compliance program. If you are making these types of calls and text messages, it's important to have one of these programs in place. As I mentioned before, and I cannot reemphasize it enough, consent is king. obtain prior express consent prior to initiating or sending any, especially any telemarketing or advertising calls or texts to consumers. I think it's important, as I mentioned a few moments ago, to provide an opt-out mechanism for consumers receiving calls. That's a great idea, whether that call is an advertising call or not. I think it's important to look at who your third-party vendors are and see if there's a level of TCPA compliance there. When you are looking at sending messages out, it's important to review and to categorize messages. As I've mentioned here, not all messages are treated the same. Advertising messages are treated very differently from informational or healthcare related messages, and so you need to be careful. Keep informational messages just that, content neutral. If you provide an informational message but it also provides advertising content, then the courts and the TCPA, you're going to be liable, or at least there's a chance you will be liable under the TCPA for sending those messages. Make your consent clear and conspicuous and user-friendly to those who are providing that consent. And then once you have obtained that consent, retain those records. And another important aspect, and I think the case a few minutes ago, the Coleman case illustrates this, is that create some procedures for tracking when consent is revoked, and then obviously honor that consent when it is given. A couple of don'ts to be aware of. I think it's important to look at your consents and don't always assume that consent received in the past is valid for all purposes. Again, if you've obtained consent for certain purposes, you can't assume that those purposes extend to all purposes, including advertising purposes. I think you need to be careful about placing any unnecessary restrictions on the scope of consent, and what I mean by that is withholding goods or services if you don't get the consent. I think you need to be careful about assuming that a device is not an ATDS. Again, this is an area that's in flux and still requires a little bit of clarity, but I think even before the 2015 decision, I think there's tended to be a presumption, at least upon by some courts, that if you're using some electronic mechanism to make a call, that it was an ATDS. So you need to be careful and know, again, what it is you're using and whether it would be considered an ATDS or an autodialer. And then the fourth and final piece of advice is to not assume that you're necessarily safe from TCPA liability if you're using a third-party marketer or vendor. There can be, in certain circumstances, vicarious liability, and so you just need to be careful and protect yourself in that way. I'm going to take the last few minutes that we have to review a few questions. So let me pull those up right now. Hold on one second. So, and this is a good question, a fair one. How do we ensure that a patient isn't charged for a text message or the message isn't counted against his texting limits? I think you've raised a very, very difficult question, and one that doesn't have a great answer. I think I will tell you the order doesn't, the 2015 order and the DC Circuit's ruling really don't give you much counsel here. I think the counsel is basically it's leaving it up to you to make sure you're compliant. And what I mean by that is they, meaning the FCC, are counting on you to reach out to providers and to see if you can if there's a way that you can determine that those calls are being charged or not. I know that's not a great answer, but unfortunately the provisions that we're given don't give a great answer of how you discover if someone's being charged for your call or for the text message. And so that's a difficult one, and one that doesn't have, unfortunately, a really great answer. other than doing a little bit of research to see how that would work, or if the telecom companies can give you some information there. So I'm sorry, I wish I could give you a better answer, but the answer is it's difficult to tell. Yes, I can give you the legal citation for the ACA international case. I think. Let me look here. Hold on one second. I had it noted here. Let me answer the other questions, and then let me get to that one, and then we'll go from there. Hold on one second. In the case of a hospital, who constitutes a healthcare provider for purposes of texting patients? In compliance with the TCPA's rule that you cannot text a patient more than 3 times a week. Is the hospital the provider, or are the individual physicians? That's a good question. I think they would break it down. I mean, if it's coming from the hospital, I think you're going to be limited, including whether that hospital encompasses those physicians. I think you're really going to be limited as to the amount of texts you're going to be able to send. That 3 times a week, I would be cautious if I were you about testing that limit. The FCC and the courts, or the FCC typically views these provisions against the caller, meaning the caller is responsible to comply, and I would be very careful in that instance. But I don't know of any guidance that separates physicians from the hospital, unless the physician unit is separate and apart. The practice is separate and apart from the hospital. Let me look at some other questions. Were Latner and Zanny decided under 2012 order? Does that make a difference? Well, you know, that's a fair question, and I know the order you're referring to, and I don't know that that it does make a difference. My reading of Latner and Zanny seems to be consistent with what we have seen in the D.C. Circuit decision, and consistent with the guidance that has come out. I don't know that it does make a difference, and I know what you're talking about with respect to the 2012 ruling, and so you know, that's a good question, but one which I think is difficult to tell. Like I said, I think it is, those decisions are consistent and don't run up against, I don't think, the guidance that we've received since the ACA decision was decided. Let me make sure I don't have any other questions here, and I apologize. Let me find the ACA's decision for you. Are there any other questions? You're welcome to ask those before I close up. And you know, the person who asked for the ACA decision, what I'm going to do here is I'll track down your email and send that to you, the ACA. I apologize, I'm having a hard time finding the reference here. For the rest of you, I really appreciate you making time for this presentation today. If you have any questions that come up in the future, please feel free to shoot me an email or give me a call. I appreciate your time today and being part of this webinar. Thank you very much, and have a nice day. Bye-bye.